Okay, here we go. Part 2, Chapter 3. Filing and procedures for court cases. How to file, what this file stuff means, how to do it, really. Okay, and you got to recognize something here. You're intimidated by the court system because they pay these lawyers so much money, and these lawyers are ruthless and will just eat you apart as a pro se. They will totally take advantage of your ignorance. However, if you're remotely competent and you can actually read and research and do some of these filings like this, you are in a whole different level. Okay? They will become more afraid of you because they won't be able to scare you and intimidate you like other people that hire lawyers. Okay? So, if somebody's and this happened to me. Somebody came after me with a lot of money and a lot of lawyers. They spent a lot of money to try to get me. And they didn't. I went through a lot of shit. They scared me. They did a lot of other awful stuff. But they could not move me. Okay? And so if you have some other private individual coming after you and they hire big lawyers, they're paying those big lawyers a lot of money. And if you can do this on your own, you don't have to pay anybody anything. So you can file a motion and they have to respond to it. And they have to spend a lot of money to get their lawyers to respond to it. So you can keep filing motions, dragging things out. It's a game changer. Okay? You got to think about it that way. That's not including actually winning in court too. Half these court cases, you wear people out till they quit. That really is it. These courts are so slow. And the process of justice is such a racket. They want you to take as much time so that you will spend more and more money. That's the whole point of it. To confuse you so they keep extorting you. All right? This case I'm talking about, we went nowhere. Nothing happened, but over $150,000 was spent. Over $200,000 was spent for nothing. Lawyers' pockets. Okay? So, pro se is a superpower. It's not really what you want to be. Don't get me wrong. You're not being seen in your living self. You're not being respected like you should be. However, these rules, the statutes are for them. They are not for you. So you can sue people because they're not following their rules. And it doesn't mean you're no longer a man or a woman. You're the people. Okay? So, super powerful stuff here. All right, let's try this again. All right, so every court is going to have court procedures. They all do. All right. Federal rules of civil procedures are the most popular. Most states kind of adopt those or share those or refer to those. Where the Colorado rules of civil procedure fall short, they go to the federal rules of civil procedure, and just down here you might not be able to read it, but this is the United States Court of Federal Claims. And it's kind of fascinating how, we've seen this symbol a lot. But then there's this symbol. And this symbol has this little all-seeing eye on it. And it says 1855. I don't know. You tell me. Okay, this is a complaint. All right, all court cases start with a complaint. It's just the first step. A lot of these, sometimes you'll get sent a complaint before it's ever even filed. And they're allowed to do that. I think it's 14 days. But a complaint is simply saying, hey, we got a problem. And we think this court can handle it. And so you file the complaint. Now, if you respond to the complaint that says none of this stuff is true, I didn't do any of this, they can't do this to me, you've responded to the complaint, and now there is a case. They have jurisdiction over both of you. And I don't really think there's anything you can do about it. I've tried very hard. Very hard. All right, I'll just tell you. I accused a judge of treason, trafficking, and slavery because he tricked me into this damn case. Didn't matter. Why? It didn't matter because there's nothing I could do about it. Unless the federal court agreed, but they're going to look at it in the same way they're looking at it, that they have their jurisdiction, so they're doing nothing wrong. Okay, so yeah, a complaint starts things off, and it can be simple. It can be a one-pager. You don't have to put your whole trial into the complaint. In fact, you shouldn't. You just need to get it going, and you got to, if you can, think about it, realizing they're going to respond no matter what. And once they respond, then you got another chance to add on some arguments or sharpen your arguments. But all right, receiving the complaint and responding to the complaint are the most important steps to staying out of civil courts. If you respond to the summons that directs, if you respond as the summons directs, you agree to their jurisdiction. That's it. Actions by both parties gives the court personal jurisdiction, and a challenge to the jurisdiction, refusal for cause, or motion to dismiss for lack of jurisdiction are the only responses to summons that won't give the court jurisdiction. So you got to be able to stand on that, and you got to keep doing it. And you can file a counterclaim in a higher court. If you keep challenging jurisdiction and they keep ignoring you, you can then file a counterclaim being like, hey, I'm getting abused down here, which is what happens. So here's how a beginning of a case will most likely occur every single time. The plaintiff is going to file a complaint. Now, the defendant can do any of these things. You can file any of these different types of things. And then the plaintiff will respond to whatever that is until they're done. And then the court will then decide if there's going to be a hearing or will rule on the motion to dismiss or any of that stuff. But you really should have to, if you're at the point now where the judge is involved and it's beyond the summons, a motion to dismiss is necessary because these courts are stupid. Okay, they don't think. They just follow paper. They just follow rules and paper. So in order to get a judge to think about anything, you got to write it out for them, and then you got to ask them to do it. And then you got to write it what they would do for them. You got to write out the orders for them. Yeah, it doesn't matter. If you file a complaint on anybody, you're going to see a motion to dismiss. And that deters a lot of people, but it shouldn't. It's just the process, okay? Respond to it. Show them how they're full of shit. If the defendant fails to get the complaint dismissed, the court can rule on the complaint or schedule a hearing. The hearing will outline the next steps in the case. If there are extenuating circumstances that would affect the court process, they are discussed then. Essentially, this hearing opens the doorway for litigation. So if you get to a hearing and you've challenged jurisdiction in all the right ways here, and they're still moving forward, then that's where you can file a counterclaim. And the thing is these civil courts do not want their business being brought up to federal court because they are running a complete fraud down here, a complete shtick. Obviously, the federal courts know about it, but they're allowing the states to be independent, right? And that's what it's supposed to be. The republic, the states are supposed to be totally independent, capable of handling their own affairs. So they should be capable of handling their own courts, except for the fact it's all a commercial trick. All right, when you create a filing, this top part here is pretty much the same all the time. All right, different names and whatnot, but this is how you should really kind of set it up. There's a title. What court are you doing this in? There's obviously the plaintiff and the defendant. Their names go here. And the one thing I don't have on here is that your original complaint should show addresses. So if you're filing as plaintiff, this little box underneath here is where you would put you or your attorney's address. All right, the courts need to have a way to communicate with you. And since you're going to do this pro se, you're going to want to do it through the mail, and so you're going to want to put a mailing address. Case number, if you know it yet. Obviously, the opening complaint, you won't have a case number. But once it's filed, there will create a case number. And there's just some special instructions. Here it says, notice of special appearance of defendant reserving issue of subject matter jurisdiction and personal jurisdiction, venue, insufficient and effective process and service, and joinder. I kind of use this all the time because you're basically challenging this whole thing. And so you are reserving the right to challenge all of it. I mean, you can challenge all of it. You'll piss off the court and piss off the judge, but fuck them. The title of what you're filing. If it's just a complaint, then it might just say complaint. If it's a complaint per some statute, then it's a complaint per some statute. But right here it says defendant's challenge to the jurisdiction and motion to dismiss. Don't believe this court has jurisdiction over people. Clearly people. This case should be dismissed. Body of the filing. Okay, after this is the heading, and then once you actually start writing, this is kind of how the body should fill out. Opening sentence addressing the court. That was on this other page. That was just a one sentence. The defendant brings this motion to dismiss to the court and says the following. It doesn't have to be crazy, but that's a single sentence addressing the court, announcing the title of the filing. The next part can be kind of in a lot of different ways. The simplest one is that you'd have that opening sentence, cause of action, arguments, conclusion. All right. Now that cause of action is really why are we bringing this case here? Okay. Now there's details in that cause that may want to be narrated. Something completely different is the statement of facts. All right. There may be other facts that just need to be established that aren't precisely related to the argument. You can do it however you want. It really just needs to be kind of concise or organized. You make your arguments, conclusion and prayer. The prayer is optional, but since we're people dealing with a satanic frickin' court, bringing some God into it is a good idea. And then you're always going to have certificate of service. Okay, and you're always going to have some kind of statement saying, I promised or I swear I delivered this to the other side. I either gave it to their attorney, I sent it to them, I mailed it to them, I dropped it off at their house. However you do it, just say that's how you did it. All right. Now, the certificate of service I was using as a boilerplate always said I sent this certified mail. And I did that most of the time. But in reality, you don't have to. There are probably rules of civil procedure that say you have to do it a certain way. But, just do your best. Make sure they get it is the most important thing. And when you file something with the court, all the lawyers are all in the same computer system. They're going to know when something's filed too. File format can be important. It'll definitely make your filings much more, they will be taken more serious. Okay, the rules for civil procedure will give you direction on how they want it. And different courts are different, especially the Court of Appeals. They have a very unique way of how they want everything submitted, and they will kick it out if they don't like it. The lower courts, not so much. Your arguments in each paragraph really should be numbered from the beginning to the end. So you can have different sections, but the first paragraph all the way to the 50th paragraph, and it's your font should be at least 12-point, double spacing. Like I said, lower courts are generally more lenient when filing formats, but some courts, especially higher courts, may dismiss a filing just because they didn't follow the rules. And you will get some frickin' lawyer out there that you do dismissed. There's an edit mark here, adding this section. It's something I just kind of came across, which I've actually kind of known for a while, but for some reason it didn't quite click for me right away, which is something that is common in this sovereignty game, I guess. This is one of them, and I think it's really, really, really powerful. If there's one thing to walk away from this, one little nugget, it's right here. How to sign, okay? When you sign your name, how you signed your name before, you signed it as being responsible for the legal person because you've given no instruction. You've specified nothing. There is just an entity. And when you just sign for it, when you just sign by the X, you're giving everybody else control to do whatever they want with it. Whatever you signed for is what you agreed to on their end. So this is how you do it. Every court case, every filing you do, right here. And it's shown here as the plaintiff, but it would probably be the defendant if you're getting sued and pulled into court. For the entity. Okay? Your birth certificate name goes right there, comma, person or legal person or commercial person. It's the entity. The person is the entity. Your relationship to it is what is in question. Okay? The courts are presuming you're the trustee, that you're the responsible individual, that when they give orders to the person, you're going to carry them out. Okay? That's when you don't know nothing. That's how they do it. But by signing this by your signature as the authorized representative, you're cutting any type of responsibility for the person. You're just a representative, right? If a corporation says an authorized representative across the country to some other corporation to have a talk, that other corporation can't make that authorized representative do anything. They can just communicate, take back information, take back notes. You declare that, but you also say, I'm only here to settle a controversy, to settle a problem. There's clearly a mistake. I'm here to settle it. What is the problem? And they're going to say your person violated a bunch of their rules or some rule. And so when you argue it at that point, you break this whole thing, because an authorized representative shouldn't be defending the corporation. They shouldn't be arguing for the corporation, saying I'm here to clear up any mistakes. And if you have enough foresight about your person and the equitable side, you can possibly ask them to discharge, set off whatever fiat expense they've come up with, and let them exchange it against, and let the state take care of it. You know, you don't have to know the whole thing. You just got to know that you're not the thing. You're not the controller. Okay? So, by, sign it, comma, authorized representative. Underneath that, write out your name that you just signed there. It's probably the same as the all caps name. It's just not. Like I said, lower courts are generally more lenient when filing formats, but some courts, especially higher courts, may dismiss a filing just because they didn't follow the rules. And you will get some frickin' lawyer out there that you might be going against that is just a frickin' tight ass that will do everything they can to get everything you do dismissed. Aha, here's the certificate of service. So at the end of your filing, you should have something like this. Like I said, I showed you two different ones here. You can populate all the plaintiff's information here and all the defendant's information here, or their attorney, and you just check a box. I certify I mailed or delivered such and such. And then you sign it. And that just has to be attached with your filing. This is another way of doing it. I did on this day, I sent it via postal mail. You can do it a lot of different ways. Conference. This is an important one, especially if you're going to be taken serious. But whenever you file a motion, and I'm not sure a motion to dismiss counts in the beginning, but if you're in the case and you have to file a motion of extension of time, motion to reconsider, motion to clarify, motion to transfer the case to federal court, you have to contact the other side, the other lawyer, and tell them what you're going to motion and ask if they agree. All right, there's nothing crazy here. It took me off guard the first time a lawyer called me and did this. I was kind of pissed off. But then I realized it was just a rule. And they're going to either agree or disagree. Or they might come up with a different idea, But conference, CRCP. Response time. You either have 14 or 21 days to respond. That's really it. Same way with the court. If you ask them a motion to do something, clarify or reconsider, they got so many days to do it. It's a good idea to always file an extension of time, especially if you're doing anything by hand. Like I'm talking here, doing it on your computer and having to go down to the clerk and file it by hand. Even mail will eat up a whole week, So pay attention to that. If you're sleeping on the job here and you miss a response time or blow it, you can ruin your whole case. There is a way to do everything online. You can register with it. I just have always avoided it, and I'm going to keep avoiding it. But it will make your life a lot easier as far as submitting stuff. If you're going to be taking this stuff really serious and doing a lot of court cases or whatever, there's a way to register online, and the courts will show you. They want you to do it. They don't like people doing paper filings. So here are some useful motions. All right, each party files motions to the court, arguing back and forth about the issues or non-issues. I mean, that's really all a court case is until you get to a trial. You have each side trying to get what they want, and they do it through motioning the court for the court to decide. So, you just motion something, and if it goes unopposed, they'll probably get it, unless they're really trying to do something awful. But that's just how it works. You got to motion the judge to do something. You're not going to dismiss the case just because you don't like them. You got to motion to dismiss. At some point, the court will rule on various issues. Sometimes they are small and just specify how the case will move forward. Or it could be the orders of the court. Regardless, there are motions that can be very helpful. So the motion to clarify why they did what they did, why they ruled how they ruled. If it doesn't make sense to you, if it's really perplexing you, motion to clarify. You said this when this doesn't make sense. Motion to reconsider. You can ask him to rethink it. Something may seem completely off. It may look like an error. Motion to stay is where they give orders or they say something can happen, and the stay is, can we hold this off until we figure this other thing out? And that's what a stay does, and they don't always give it. But those are motions. There's other ones, but those are ones that I've used that are useful. Fees to pay for your court cases. There's always a filing fee with the first complaint, and the type of complaint. Different. Federal court's more expensive than state courts. But once you have a case, motions and whatnot, excuse me, should not be. There shouldn't be any fees for them. Criminal case. If you're defending yourself in a criminal case, the police are going to be involved with you getting served and whatnot, and they're really going to try to make sure you can't get out of that. And it's pretty yucky. But it's something to really understand. The state is a corporation. That judge is an employee of the corporation. The district attorney is an employee of the corporation. The prosecutor is the people of the state of Colorado. That's not a real thing. There is no entity out there, organization, anything that's titled the people of the state of Colorado. It is purely a rule, a statutory rule. The Colorado Revised Statutes flat out say anytime there's a criminal case, the individual is going to be prosecuted in the name only of the people of the state of Colorado. Just the title of a thing. So the judge, the DA, and the prosecution entity are all the same thing coming after you. It's not fair. It's not justice. It just looks like it. It's just the story. Yeah, all criminal cases, despite the name of the plaintiff, are brought by the state corporation. Judges are the state corporation, the prosecuted by the state corporation. It is you versus the state corporation. But the same challenges to the jurisdiction in rebuking the presumption apply. More filing tips. There's a lot out there, but if you keep it simple, you can do this stuff yourself. I've been a part of probably 6 or 7 different court cases, mine and helping other people. And, just drafting a paper, the filings properly, make them look good, will serve you immensely. Okay, the complaint is not the trial. Okay, if you're going to file a complaint with somebody, you don't need 300 pages of evidence to submit with the complaint. The complaint just gets it started. If you file a complaint, you only need to make the argument of a controversy that the court can rule on. Evidence and the exhibits are not required, and organizing exhibits is time-consuming. Writing up the complaint can be done pretty quickly, but organizing all your exhibits, that's the real time suck, and it's not necessary. Pro se is an emotional thing, man. I'll tell you what. Uh, it's very hard to hear the other side defame you and keep your composure. I typically take a day to read a motion once it's filed, or I get it, and it can be triggering. And that's if there's a value to lawyers, that's it. Is that when somebody else files something, they can kind of massage it for your ears first. Like it gets old hearing a high price lawyer constantly challenging your mental fitness or your grip on reality because you're doing something different. It freaking is really hard. So recognize that, and in all your arguments, whatever argument you're trying to make, both as in defense or in prosecution, you use the state statutes if you're in the civil law, the state courts, the county courts, because they absolutely have to follow those. Okay, I brought up the Constitution. I brought up the Fourth Amendment in the case, and they said it does not apply in civil law, civil courts, because these are all commercial courts. So once you're in there, your constitutional rights go away. So making constitutional arguments is fruitless. But the state statutes they can't get around them, and the Constitution for the state that's even more powerful because the statutes can be argued. Okay, and they got to be proven that something happened. The Constitution, it's effective law all the time. So if there's evidence that somebody violated the Constitution, there's a problem. If there's evidence somebody violated a state statute, they can actually choose not to apply the statute to somebody. Oh, you violated the statutes? Okay, well, we're not going to hold you to it. The Constitution's different. Okay, that was